Okay, I think that's probably about the green light. This means we're ready to go. Good afternoon, everyone, and welcome to the November 10th Board Policy Committee meeting. I am Amy Goldman, chair of the committee, and I want to welcome everyone here today. We have some, at least two new faces today. And there's Mrs. McMenamin. So we'll start with her. We have our teacher representative who just appeared. We also have our administrative liaison, George Regal, and we have Dr. Hand, our technology director. We have our solicitor, Mr. Diazio, Superintendent, Mr. Batchelor, and fellow committee members, Mrs. Stern, our vice chair, and Liz Duffy. Also want to welcome Austin Johnson, to our student representative to the committee. This is your kickoff meeting for policy, right? So welcome. Buckle up. Here we go for policy for the year. It's a pleasure to have you on the committee with us as our student representative. With that, I'd like to turn it over to Mr. Regal to provide some administrative remarks.
Awesome. Thank you, Amy. And yes, welcome Austin to Policy Committee. I hope everyone's enjoying the weather we've had these past few days. It is absolutely gorgeous out. Tonight we have multiple policies up for discussion, most of which are first reads. Policy 104 is the only policy up for a second read, and we'll discuss that when we get to the agenda item. As a point of clarification for the committee, policy 248 was up for a second read this month, or last month, excuse me. However, due to the discussion and recommendation last month by the committee, the policy was pulled and is back on the agenda today as a first read. And this is due to the nature of the changes, which we'll go over when we get to that item. It works out better as policy 348 is also up for a first read, which is a corresponding policy. Policies 448 and 548 are up for a first read repeal. And as a reminder, that's due to the 300, 400, and 500 categories beginning to be collapsed as we move forward into a new 300 category. And Ed will review more when we get to those agenda items. And finally, we have policies 815 and 829 up for a first read, which are both technology policies. And Scott Hand is with us to go over some of those changes or answer questions as we get to them. There were changes, these changes to the policies are also in the corresponding ARs, which we will review. One final item regarding a board policy that's actually already posted on the website. That's board policy 005. In that policy, there's a heading that currently reads board liaisons. However, that heading should read board committees, as the content underneath that heading is about committees and not liaisons. So that's already been corrected, but wanted to make sure that the committee was aware. Back to you, Amy.
Okay, great. Thank you for that, George. And just as a reminder for perhaps Austin or anybody else who might be watching, there are changes we make to policies that are either substantive or non-substantive. The changes you were talking about for policy 005 are considered non-substantive, and they can be changed by the administration without going through the regular policy process. So I just want to make sure that everybody understands why that was quickly changed. All right, let's.
Ms. and yes. Amy, could I jump in too? Just though tonight in policy, we're not discussing any of the recent updates I provided the community, this past Sunday and last Friday, about our protocols and what we've been doing with the spread of COVID and our status in hybrid, and we're continuing to stay in hybrid. But tonight, before each committee meeting, I just wanted to mention for those people who are tuning in and for our board that, the last 2 weeks I've had to send out messages, just sharing with our community that we are, as of today, and I've been saying and joking, as of Tuesday, 11/10 at 5:03 now, we are planning to stay on hybrid. But the community spread in our county is concerning. And our experience as Radnor is counting for a lot, but our experience is also concerning. We are seeing incidents, and we're especially seeing incidents of spread outside of school. And there's going to be a tipping point where those incidents and those things that happen outside of school are eventually going to be coming into school. So I want to encourage the message I'm sending to all our principals, I'm sending to our community, is that we've got to follow our protocols, the importance of masking, the importance of doing that check each morning when people don't feel well to not come to school, how critical those two items are, and then also how critical it is for all of us to make sure that we're following the protocols even outside of school. We're finding that it is social gatherings, the county is finding, and the health department is finding that it is an expanding of everybody's bubble. That, if you got together with one or two neighbors, now it's 3 or 4 neighbors, and that a lot of the incidents they're seeing in the county and the spread is not only because of Halloween, but it's also because of the expanding bubble everyone's experiencing, and different activities, whether it's a travel sports team, whether it's another program, whether it's social gatherings. But that is what the county is finding as some of the spread that's taking place. So we want to keep school open. So I'm taking this, sorry for jumping in at the beginning of the meeting, but at each committee meeting, I want to just take a moment to encourage our community to continue to be vigilant. We want to keep our kids in school. We want to make sure that we're doing this safely. And so together, and which our community has shown that we can work together to do this, we need to continue to work together to keep our schools open. So on to policy. That's not the topic for tonight, but just when I have an opportunity, and I have at least all of you listening, I could mention that. So thank you.
Yeah, my pleasure. And that's a good segue for public comment. That was admin comment. And now we're at second admin comment part 2. Now we're going to transition to public comment if we have any. Anybody who's monitoring public comment tonight?
That is me. And hold on one second.
Okay.
No, we're good right now. We'll check it at the end of the meeting.
Okay. So with that, we move into approval of minutes, and a board member has raised a concern about the minutes. So I think we're going to pull them until those things can be addressed. And if anybody has any other issues with the minutes, please feel free to reach out to me. You're welcome to express it now in front of Mr. Regal, or reach out to Mr. Regal and me after the meeting. But based on the concern about a certain part of the minutes, I know already they need to be pulled, so we don't spend too much time on them, and we can approve them at next month's meeting. Does that sound good? Does anybody else have anything else that jumped out at them that needs to be addressed right now? Okay. All right. So we will let it be noted that we're pulling those, and we'll move into our first agenda item, 4.1, Policy 104, Non-Discrimination in Employment and Contract Practices is how that policy is currently titled. Mr. Regal?
Sure. So I did make some notes in the right under the agenda in the paragraph at the request of the committee last month, just so a couple things stand out. As Amy just pointed out, that is a current title. The new title will be Equal Opportunity and Non-Discrimination in Employment and Contract Practices. This is up for a second read, and it was one of the policies that was updated due to Title IX. Ed, anything to add?
Well,
Yeah, nothing to add.
Could I just clarify that it's titled on the agenda as Non-Discrimination in Employment and Contract Practices. Is that the current or the changing title?
That is the current. That is a current title. The new title will be Equal Opportunity and Non-Discrimination in Employment and Contract Practices.
Okay. Well, okay. I'm sorry to be stumbling on this, but
The new title is
Equal Opportunity is the new part. Is that those are the new words? The equal opportunity is what's being added to it.
Yes.
Okay. All right. Thank you. All right. Does anybody have any? Let's go around and see. Start with. I guess I usually go with order of seniority here, reverse order. Austin, do you have any questions or comments about the policy you'd like to raise?
Yes, I have one question. In the delegation of responsibility section, the Director of Human Resources, it was redlined to say that what was redlined was the distribution of the policy annually. Will the Director of Human Resources, do they still have to distribute it annually, or is that mentioned in a different document? Does that make sense?
Okay, who wants to answer that?
Let Ed answer that. I'm not sure.
Sure. So this policy, under the new Title IX regulations, the requirements for distribution are that the policy be posted online and incorporated into a grievance process, which we have also posted online. So instead of a lot of the policies that used to call for physical distribution, as the district moves to more electronic-based documents, a lot of the
Ooh,
putting on the website or sending out electronically. So that's why you saw that taken away. And this document will be posted in multiple different places on the website so that it's always accessible to anybody who's looking for it. It's a great question.
Thank you.
okay, thank you, Austin. And thank you, Mr. Diazio. Mrs. McMenamin,
I'm good.
you're good? Okay. Liz?
I have a question regarding the AR. Do you want me to hold off on that?
No, if it's, let's see what the question is and we can go from there.
Well, I just had a question because I was curious sorry. What would we do if the actual claim was against the Title IX coordinator or the HR director? And I'm referring, if you look, I'm jumping ahead, but when you look at the harassment AR for that we're going to review later, there's actually a line that says if the Title IX coordinator is the subject of the report, then it shall be reported to the or handled by the superintendent. And we don't have any clarifying language there on this one.
Oh, I kind of thought we did, but all right.
We do. Am I missing it? I thought I didn't see
Wait,
anything.
it's not worded the same exact way, but at the very bottom of page 1.
Page 1 of the AR.
It says the Title IX coordinator or other superintendent designee shall conduct an adequate, reliable, and impartial investigation. It's not worded the way that you're saying it's worded in the other one. I agree, but
I just meant since it seems like we're talking about like all of this is directed, you know, the director of human resources and the Title IX coordinator who are the same in our case. It never clarifies what if he's the subject or she, and in a future date, the subject of the discrimination.
So Ed, do you have a thought on that? Mr. Diazio?
I'm scanning the AR now, and I agree with Mrs. Duffy that I think it's not in here. I think the thought in the drafting of the policy is generally with this policy, the complainant is usually not always not, but is generally not an individual person, and usually what's being claimed as being discriminatory is sort of an employment practice or a process that someone has gone through to maybe apply for a job, or maybe, you know, through a review process, they don't feel that they were rated a certain way, or, you know.
Right, and I'm thinking that person is usually, it's the human resource director that's responsible for that, so.
Yeah, I mean, to your point, in a lot of the policies, we generally do indicate what happens if the Title IX coordinator is the subject. The good thing here is that we can make the change we can add something to the AR, just to indicate that if the Title IX coordinator is the subject of the complaint, then someone else should be the person who's notified, and then a proper investigation will be handled by the superintendent's designee is likely what it would read. But I think we can put that in the AR, and we can continue to move the policy forward if that's the desire of the committee.
Yeah, I would anybody have any objection to that? I certainly wouldn't.
so, it's not so much an objection. It's just the distinction of this policy is saying that we're going to have equal opportunity and non-discrimination in our practices. And you wouldn't, if someone took issue with our practices, it would be a charge against the district. I think that's what, Ed, that's what you're trying to say. It would be a charge against the district, not against a person, because if it were a discrimination issue against a particular person, I think that would be covered under a different policy, correct? I mean, it doesn't hurt to hear that, but I don't know that our human, well, let me put it this way. If that, in the case of this particular policy, at the end of the day, all charges of violations of this policy could be construed as against the HR director because they're the person who handles all of our employment practices. That's why I don't think an issue with our practices couldn't be against an individual person. It would be against the district as a whole, because otherwise every employment practice at the end of the day falls under the HR director, who happens to be our Title IX coordinator, correct?
That's correct. And I think, Ms. Stern, you're correct that that's generally how the cases come forward. I could envision, though, a case, let's say the director of human resources is the individual that's responsible for evaluating his or her administrative assistant. And the administrative assistant feels that based on their any protected class, gender, race, age, that they were provided an unsatisfactory rating. And one individual was responsible for assigning that rating. Presumably that complaint could be brought under 104 against an identifiable supervisor. And for anybody that the director of human resources supervises, it could be. Now, again, I think it's generally less frequent because it's one person that we're dealing with, but it could happen. So I don't think it hurts to add the clarifying language just in case.
Yeah, I don't think it hurts. I was just making the point that this particular policy has to do with practices, not individual action.
Sure.
Yeah. So I don't have a problem with adding it in the HR, but it's just the nuance of what this particular policy is saying.
Yep.
Well, those
Right.
practices could also be an individual superior to subordinate evaluation somewhere, and you could see somebody perhaps wanting to take that person, like Ed was saying, to task for it, not just the district. So,
Right.
but are you, Liz, did you have anything else? It sounds like, Ed, you're going to agree to make that change. It will not hold up us moving this forward for a second read in 2 weeks. Liz, do you have any other questions?
That was it.
Okay, thank you for that. Susan, do you have anything with 104?
I just, I don't know why this never dawned on me before, but Mr. Diazio and George, I thought that Title IX only pertained to students. So, or is that not the case?
There is guidance out there that does suggest that in the context of sexual harassment, employees do have rights under Title IX. It's
Okay.
not very intuitive to think that way. I think you're right. I think when we first saw the guidance, we were questioning, how are employees implicated here, but they are.
Okay.
Yep.
So that's it, Susan?
Yes.
Good? Okay. My only comment is in the purpose, I think there's a word missing. The second sentence says discrimination is inconsistent with mission and goals. I think the word "the" needs to go in front of mission.
Okay, I'll make that change now. That's correct.
Okay, thank you very much. And with that, I think we're ready to move that on for a second reading at the November business meeting. And we'll move to our next policy item, next policy agenda item 4.2, policy 248, unlawful harassment.
Sure, Amy, I have a question if you're okay with it. We have Scott Hand back, so he doesn't have to come possibly back for a third time because he got bumped last month.
Yes,
Would we
let's do
mind?
that. No,
Okay.
not at all. So we'll go to 8:15 before, and then 8:29. Are you staying for both, Scott? Okay.
Yes.
All right, so
Yes, ma'am.
we will jump to policy, agenda item 4.6, policy 815, acceptable use of internet and network resources. Do you want to tee it up, Mr. Regal?
I will, sure. And Scott, again, thank you for joining us. So the policy was identified for review, just part of a routine review of policy. However, due to the pandemic, there were some changes, and Ed and Scott actually met this past month to review. We're using a lot more, instruction is occurring a lot more on technology. So we want to make sure that our policies are solid. And that really goes for 815 and 829. 815, the acceptable use of internet and network resources is the current title. The recommended title will be, if it passes, acceptable use of technology. So that's removing or changing the wording a little bit in the policy. The policy was up last month on the agenda. However, it was pulled in order to bring it onto this month. Oh, I apologize. No, 829 was not 815. Ed, is there anything to add? And then Scott, we have here for any questions.
May I ask you one question about your introduction, Mr. Repeal? Was it really up for routine review, or did we pick this policy given that we were going through the such distance learning and everything?
So it was on the list as a routine review. I think because of the pandemic and those changes, we looked at it closer, looked at any other changes we needed to make due to the instruction occurring more online, but it was listed as a policy that was up for review.
Okay, thank you. All right,
Sure.
so Mr. Diazio, did you want to add something to that before we give you some feedback?
I don't have anything else. I'll wait for questions.
Okay, and Dr. Hand, did you have anything that you wanted to add for context before we start discussing the policy? Nope.
I don't think any more than Mr. Regal added. It was a good time to go
Okay.
through and do a modernization and an update on a lot of the language.
Okay, well, I know it was a lot of work, so thank you for doing that and preparing it for us to discuss today. So let's see, Austin, do you have any feedback on 815 acceptable use of technology?
No feedback or questions.
Okay, Mrs. McMenamin?
Nope, I'm good.
Okay. Oh, welcome. Jeff Jubileer is here. Should I give you a moment to settle in, or are you ready to hit the ground running?
My report is that the Radnor JV girls soccer team was victorious this afternoon.
Oh, congrats.
Woo!
It is-
Now, that's wonderful. Can we pivot in a
I
really
can pivot.
short-
I'm ready to pivot.
Policy 815, do you have anything you want to share about policy 815? Any questions or feedback or anything?
On the acceptable use of technology,
Yes.
not at this time.
Okay. And Liz?
I have a question about the AR again. So
Okay.
Should I do the AR? Okay, one's just a question. I wasn't sure what it meant in the very first paragraph, which says whether connected to an electronic network or operated on a standalone basis. That's my lack of technology understanding, but. Did you hear me?
This is when I turn it over right to Scott
Okay.
because I'm not sure.
Yeah, give me where you are again.
It's just,
Please.
it's the first, it's at the AR, in
Mhm.
the AR, the very first paragraph. The the first sentence actually, but it says will be applicable to the use of all district technology resources, whether connected to an electronic network or operated on a standalone basis. I wasn't sure what standalone basis meant.
So that would be likely, and I'll let Mr. Diazio come in as well, is where it goes over to the personal devices, looking at 829. So basically, not just district technology, because that's what we tend to focus on, are the things that we own, but when other devices connect to our network as well. So the way to think about 815, and with the language adjustment, the title adjustment, that it's acceptable use of the network resources or electronic information. Devices are contained either within 829 or under 224, which is care of school property. It's more about the use of the network systems and information.
And then I just was wondering, back further down, we talk about, I guess, 1, 2, 3, it's the fourth paragraph. And you list the places when using district technology resources as they would in the classroom, school, hallways, buildings, property, bus stops. We use et cetera. I was just, given our current environment, wondering if we should actually specify home. I know it could fall under et cetera, but it's acceptable use of technology, and we're talking about our technology, correct? So it's just the question mark there.
Are you in the policy or the AR, Liz?
I'm in the AR.
They are.
Where in the AR are you?
Fourth paragraph,
Okay.
we
So-
do a
Under
listing,
general expectations.
general expectations, yes, sorry. And we list And I'm just thinking, given it's hybrid, would we want to include just call out home?
I think it's a good point, and I think it's well worth inclusion, but I'll let Mr. Diazio speak to it. But given that it's an AR, I think should absolutely add it.
Yeah, I don't have any concern with that addition, and we can either specify home, or we could do it that way, or after the word classroom in parentheses, we could just put, virtual or in person or something like that, just to utilize, if we want to try to use the word virtual or hybrid or something like that, so that somebody reading this might connect it to the current circumstances. But either way is fine. I defer to the committee on the language that you'd like to use.
Liz, since you raised it, do you have a preference?
I do not.
Okay, does anybody have a preference? Otherwise, I'd like to leave it maybe to the Mr. Diazio and the administration to make that fix, however they feel it's most appropriate. Okay, anybody object to that? Can we leave it in your hands, Mr. Diazio and Mr. Regal?
Yep.
Okay. Liz, do you have any questions about the policy? I thought
No.
you
I do
didn't have one. Okay. All right. Isn't that it?
That's it.
Okay, great. Thank you. Susan?
Yeah, I actually have two questions as it relates to the definition for the policy. Only because I think this technology is slightly different. I'd like to request from the committee that we add the word drones to definition number 3. I think drones are different enough from all of the listed items there. And I know the district owns drones. And I think that they are a piece of technology that is actually quite potentially misused.
And we have a
So-
drones policy too.
Pardon me?
We have a drones policy.
We do have a drones policy. So, Ed, is everything that's in the drones policy covered here? Is it overkill to add the word drones to number 3?
No, I think it's absolutely appropriate.
Does the committee have Amy, you can see the committee better than I do. I think it's a safe thing to add that particular thing because it is pretty different from the rest of those listed there. The other question I have, Dr. Hand, number 5, web and cloud-based applications provided by the district through a third party. Do we have web and or cloud-based applications that are provided by the district that are not through a third party, that we just provide them?
In a sense, most everything's provided by a third party. We don't do much software development on our own. So web and cloud-based gives us the ability to look at something that might not be running on our network. So say Schoology, for instance. Schoology does not exist anywhere on RTSD property or really go through our network until it comes through the public internet. But allowing the classification to say any service to which we have subscribed as a district falls under acceptable use. That's why
Okay,
we
yeah,
included web-based.
I'm asking a slightly different question, but I think you've kind of answered it. So basically, any cloud-based or web applications, we would have to have developed them, or they are just provided through a third party. So we're covered for everything. Okay, then that's fine. That was more my only questions, Amy.
Okay, great. Thanks, Susan. My 2 questions are in the purpose. Again, there's a word prior to goals. It's among the last 3 or 4 words. The phrase is consistent with the educational and operation goals. I think that should probably be operational goals of the district.
Correct. I've made the change.
Okay, terrific. Thank you. And then the second to last paragraph, Dr. Hand, I assume you are the Director of Technology, Innovation, and Instructional Design?
That is me reporting for duty.
Oh, that's a 21st century title. Okay. That's really cool. It makes us feel like we're really happening. Thank you. I just wanted to confirm that. And the other thing I wanted to mention, Mr. Diazio and Mr. Regal, is that the cross references, I think there's an issue with those down there. 317 and 517, those 2 policies are not on the books as far as I can tell. I looked on board docs and didn't see 317 and 517. I did find a 417, but I did not see a 317 and 517.
Ed is scanning.
Yeah.
He's fast. He's a multitasker.
Yes, and what we probably, it must have just been I'm just checking to see if it would have been like 327 or 337. My guess is that there was either a number that was transposed or, but we'll find out what the proper.
What is that? What did you think that policy was? I'm forgetting what 417 was off the top of my head when I looked.
417 is conduct and disciplinary procedures. So it could be that policy.
Okay. So just if you look at that group of citations, that's my one thing. And then interestingly, policy 911.1 is it's called social media. I wasn't quite sure why we were cross-referencing that here. It might be totally appropriate, but I'd just like to know more about that. And the second thing is that if we are really employing this as a reference, I wanted to just put this on the radar that policy hasn't been updated in a while, and might want to take a look at that, because there are some things in there that I think don't cover some situations that have been on my radar in the district recently. I won't go into them right now, but I just thought maybe that to put a pin in that and think about that policy perhaps. I don't know if that would be you, Dr. Hand, or Mr. Petiti, or both.
It'll
But
probably be all of us. On the
yeah,
call here.
so I just wanted to put that out. And could someone speak to why, if 911.1 is supposed to be, where the application of that is in this policy? Why it's cited?
It's probably a little bit of a distant cross-reference. However, the district's social media presence, it's probably a little bit of a distant cross-reference, and it may very well have been carried over from. Because I don't recall adding that citation this time around. So it was probably in there before and arguably could come out.
Amy?
I'm not my thought, but go ahead and say yours.
I would think that if we're using district technology for social media, then our social media policy would apply. I mean, the
That's
kids,
correct.
students using our computers or actually any district employee using our computers to push out on Twitter or Facebook or, any other platform, I would think our social media policy would apply.
Yeah, I could think of others that, I don't think there's anything wrong with it, but it just didn't jump out at me as like a really obvious. Sometimes we have these ancillary policies that come into play, and it just didn't strike me initially as one that's like a dead ringer for being a critical part of this policy, but I could be wrong. That's why I was just asking for somebody to speak more to it. So I leave that to the judgment of you, Mr. Diazio, along with
I
Dr.
think my
Hand.
recommendation would be to remove the cross-reference if the committee's comfortable with that.
Yeah, I am. And for that matter, you have 218 in there, which is student discipline. Do you, maybe you're more comfortable with leaving that one? And when I see some errors in the cross-reference section, I just sort of want to make sure that's been looked at along with everything else.
But Amy, wouldn't student discipline apply?
Yes.
It
If a
might,
person-
I think it does, but I'm just making sure that before we move off this, because there were a few things in there that are not on our books, and there's something else that's sort of questionable. I'm just asking for a double check of the cross references before we put this policy, move this policy on, if that's okay.
So my recommendation would be to leave policy 218 as the cross-reference, because certainly violations of this policy would be addressed by the student discipline policy. And you're correct, Mrs. Goldman, that there is not a 317 and a 517 regarding disciplinary procedures. We'll have to take a look at whether there should be. a policy for discipline in each of the employee sections. But for now, since those policies don't exist, I've removed 317 and 517, and I've left 417 because certainly if a staff member violates this policy, the staff discipline policy would come into play. So that's why the discipline policies were cross-referenced as they should have been. But you're correct, that 317 and 517 don't appear to be on the books. So we'll look into why that is and report back.
Great. And you'll just also take a look, maybe keeping the add to the list, maybe if you think it's necessary, 911.1, given, don't think that's been updated in quite a few years. So,
Sure.
all right. Does anybody have any other questions about this? Otherwise, we can move this along for it's first read this time around, right? Because we didn't get to it last time. Right?
Yes, it's the first
Okay.
read. Correct.
All right. Well, how does that feel, Dr. Hand? Your hard work is now on its way for a first read at the end of the month. So,
That's great.
okay, super. And that means we will move on to the second policy you were working on, which is 829, personal electronic devices. This is a new policy, right, Mr. Regal?
Not a new
Oh, no, not
policy.
new. Right. Sorry about
Yep.
that.
Yeah, again, it was up for review. There were some changes. It was on the agenda last month, so I corrected myself earlier, but we didn't get to it. So there actually were some minor changes after Ed and Scott spoke. And again, the policy currently reads personal electronic communication devices. We're recommending that the title be changed to personal electronic devices. And I'll turn it over to Ed if there's anything to add, or Scott right now.
Nothing additional from my standpoint, other than I'll note proactively that we will correct the 317, 417, 517 cross-reference in this one as well.
Okay, thank you for that. All right, so let's see. Austin, questions?
Questions?
No questions or comments. Okay, Mrs. McMenamin? You're muted, but I think your lips said I'm all good because that's been your answer, so, right?
Yeah, no, I'm good for right now. I might have a question in a minute, but I'm good.
Okay, super. I'll circle back to you. Mrs. Duffy?
I'm good.
You are? Okay. Jeff, where'd you go? Oh, there he is.
Yeah, if you could circle back to me, I may.
Okay.
Not at
And
this
Jeff,
time.
I'm sorry, did I forget to circle back to you for 8:15?
Me?
Yeah.
No, you got me. And then I was good. Thank you, though.
Okay, so I'm going to circle back to Jeff and Andrea. Okay, Susan?
I just want to clarify in the guidelines, the last sentence of the guidelines. Files or other information placed or stored on district technology are subject to review and may be deleted without notice. Ed, do you feel like it's clear enough that that could mean personal files or all files or any files? Because I think that that's what that's intending to say is if you put your stuff on district owned devices or you put your own stuff on district technology, it could get deleted, even if it's quote yours. Is that what that means to say, right?
Yes, and generally where this comes into play is if a student has some sort of, if there's some sort of inappropriate material that's being saved, to a cloud storage account or in a student's, online storage or something like that. I mean, I think it's clear that it applies. There's no qualification that it doesn't apply. It's a pretty blanket statement, but if you think there's
Okay.
clarification needed, that's fine. But I think it's fine as written.
Yeah. Okay, great. Thank you. That was my only question, Amy.
Okay, thanks, Susan. Mrs. McMenamin?
No, I think I'm good. I just had a question because in reference to, for example, when we went virtual last year, a lot of staff was using their own phones to communicate to parents and such. So where does that fall into district policy when we were using a lot of our own, our home phones, our cell phones to communicate with parents? Does that fall under this? Like, are our cell phones then subject still to district policy in a situation like that? If we're using our own devices, because that's all we had to communicate with. So it might be just I'm not sure if it fits into this, but it did come up several times because people were reaching out, using our own phones and whatnot to reach parents. So people were just curious. I didn't know if this falls in the realm of these policies or not.
Good question. Mr. Diazio?
Yeah, it could. So for example, if you're using a personal device and there's an allegation that you're using your district email account inappropriately or sending, let's say you have your job as a teacher, but you also have a part-time job on the side, and there's an allegation that you're using your Radnor email account, for example, to conduct a side business for personal gain. Even if you're using your email account on your personal device, the fact that you're using district technology resources, meaning the district's email server, you would still be subject to the requirements of the policy. So basically, the same rules apply with personal devices as they do with district devices, to the extent that you're performing work for the district.
Okay. Thank you.
Does that help?
Mhm.
Okay. Jeff, did you have a question?
I don't think so. I think my question, Amy, Ms. Goldman, is more related to, and I think it's more applicable to maybe looking at 9/11 with the social media policy. I think that this covers, when I reading in personal electronic devices, that whether social media would perhaps be covered by online applications. Clearly, this is well thought out. So I'm just sort of talking it out, but I think unless Ed, you have Mr. Diazio, you have something. I know that my questions may be more applicable to the other policy that Mrs. Goldman brought up a few minutes ago.
Yeah, and we can definitely, George and I can regroup for a future month. I think it's certainly reasonable to take a look at that social media policy.
Yeah, and I think too, because some of the social media applications, for example, Snapchat, and I'm no expert, maybe Austin knows more than I, things come and go, but they're obviously archived or could be found through appropriate means.
Yep.
Okay, up, Austin.
Kind of building off of Mrs. Duffy's question from a previous policy, would the at-home perspective still apply to this policy? So personal devices at home during school hours, like in the virtual world?
Only to the extent that you're, like if you're at home using your own personal device to order lunch or something like that, that's not subject to this policy. But if you're using your phone or your own tablet or something like that to connect to virtual learning, and then let's say there's an allegation that two students are sharing inappropriate pictures with one another on their personal devices while they're in the virtual learning. Just because you're using a personal device doesn't mean that the district can't, for example, discontinue the sharing of those photos or discipline you for discipline a student for sharing inappropriate materials if it was shared through there has to be a connection between the personal device and a district network device. So to the extent that you're only using your personal device to do personal business and you're not at all connected to a Radnor piece of technology, then generally this policy doesn't apply. It only applies when you're using a personal device to connect through the district's network.
Okay, thank you.
Does that make sense? Was that?
Yeah, that makes sense. Thank you.
Okay. All right, great.
Okay, and the only question I had was.
Wait, Amy,
oh,
I
sorry.
actually have a question.
Oh, sorry, Susan.
That's okay. So actually, something that Mrs. McMenamin said is sparking a question for me. And I don't know that I have the answer, but I guess I would say we might, perhaps those of you in administration might want to give this some thought. So I think the presumption of this policy, and I could be wrong, but I think the presumption of this policy is that people are opting to use their personal devices for whatever reason. And I can't see all of you at once. I have to be on my phone tonight, so right now I actually can see Mrs. McMenamin. To the extent that the pandemic is causing, some teachers, some students to be at home, not necessarily by choice. And I think this is the circumstance Mrs. McMenamin was raising, is that a teacher is at home teaching from home, and they don't have the opportunity to use their district phone, for instance, to call a parent. And I think that's where I think, what I heard Mrs. McMenamin asking is, what's the guidance, what's the regulations, what's the acceptable use policy when circumstances are causing our employees or our students to not be able to use their district devices. Mrs. McMenamin might be in her classroom at school and calling the parents on her school phone. That's a very different circumstance from being at home and not having the ability to use her district device. So I think that's kind of where, Andrea, is that where your question kind of rested?
Yes, that's pretty much.
This policy presumes I think this policy presumes a choice to use a personal device rather than a necessity. And the other piece of that, although I'm reading through it pretty carefully, is that while this policy pertains to devices that you're using to connect to the district technology and the district programs and all of that, at least the way I read it, it doesn't actually also cover someone's personal internet connection. Whether they're using cable modem or what does Verizon use, DSL, or this thing that's not actually an electronic device. So there's a little bit of a gray area of when you're using your home internet connection to access the school. I don't know if there's guidelines there or not. And again, this for me is in the realm of, given the pandemic, when it's not an option, when it's really pretty much a necessity given the circumstances. And I don't have an answer about all that. I'm just saying, I think that's the circumstance that Mrs. McMenamin was kind of floating out there as a question. Correct?
I think that gets beyond this policy, gets to more employment situation. And, our buildings, our schools in the spring were open to our teachers. I had many teachers who had expressed concerns in the spring. They were welcome to come into their classrooms and use, our technology, our wireless network in the spring, and also, when we started the school year. So that's not an acceptable use conversation. That's a conversation about employment. And then what does an employer provide or not provide? So that would be something, a different discussion, I think.
Yeah, I wasn't necessarily saying it was covered under this policy, Ken. I thought that's what I was kind of hearing Andrea ask. And there is a little bit of there may be a gap. And to your point, it may very well be covered by some other policy, which is great.
I'm not necessarily it's covered by some policy. I think it's a separate discussion beyond this policy. I mean, I don't.
Right. Yeah.
That's all I'm saying. It's a separate discussion beyond this policy.
Okay.
Okay.
Amy, I don't have any questions about the policy per se.
Okay. Sorry for the phone ringing in the background. My one question, and my mistake, I think this may fall more under 815 than 824, but I had raised this in one of our planning meetings, and that is that PSBA had put out a policy in 2015, 824, maintaining professional adult/student boundaries, considerations for a digital learning environment. And I was just wondering, I know that from talking to Mr. Regal that issues around that you felt, Mr. Diazio, were covered in other ways in our policies. Could you just briefly speak to that? Because I do think that that's an important issue.
Sure. So there's a maintaining appropriate boundaries policy that's been recommended or put out as an optional policy by PSBA. I think that's certainly a worthy policy to take a look at. I think a boundaries policy is helpful to have. I took a look also at the revisions they've proposed to their policy that only apply to the remote and virtual learning scenario. And some of those languages, some of the language in their revisions was sort of just recommendations, best practices for how to effectively communicate, you know, in a digital setting, in a virtual classroom setting. The language in the revised policy didn't strike me as board level policy. Certainly, supervisors impose expectations on their employees as to, you know, how you should be conducting yourself during virtual learning. So certainly the district, whether it's been through the superintendent or through the HR office or maybe by individual building principals, has certainly communicated with staff about what the expectations are. You know, you should be, if you're when you're engaging with students online. I think that guidance to staff is completely appropriate to go directly from a supervisor to an employee on a case-by-case basis, depending on what that employee's role is in the district. So my sense was that the revisions for the current online environment were not necessary. And what I had mentioned to Mr. Regal was perhaps in the future, we might want to take a look, or we could take a look at whether the basic maintaining appropriate boundaries policy with students is something that the board would want to consider. And we could take a look at that, but I didn't feel that the online component was time sensitive or critical, given that I know that the district has given guidance to staff about expectations in online learning.
Okay, great. Thank you. I appreciate that definition. And I would, you know, just be interested in just some really top of mind, quick feedback, and we don't have to get it today, from the committee and Mr. Batchelor, Mr. Regal, if everybody, whether or not you think setting up, employing that kind of policy for appropriate boundaries between students and staff might be something that we want to do at some point. So we don't, again, not for discussion now, but I just jumping off from what Mr. Diazio said, maybe we can talk about that at some point and see if we want to pursue that. All right, so with that, I guess that means if there are no other questions or comments, that 829 will be going for its first reading at the end of November at our business meeting, right? So with that, it's 5:52. I think, should we see, Susan, do you have a little flexibility if we try to get through 248?
Yeah, I think we should try to press on and do these next.
Because your
few
next
items
up for meeting,
quickly,
your
yeah.
meeting is next. So if you can indulge us in case we need a few extra minutes, we'll carry on. And we'll say thank you to Dr. Hand for his work in helping us with the two policies we just discussed. And we'll go back to our agenda where we're talking about item 4.2, unlawful harassment policy 248.
Yeah, we just made a note in the paragraph. Just the only update was there's a conversation last month by the committee regarding a line in the policy related to students. So the policy now provides reporting procedures for students to report harassment regardless of the individual accused of harassment. There was some questions, conversation last month on, who was covered, who was making the accusation, who was covered, and what implications that had on the policies. There was a substantive change to that policy, which is why it's on the agenda for a first read again. Ed, anything to add?
No, that's correct. And just for the committee's benefit, we've removed the sentence from 248 that said this policy only applies to student-on-student conduct, and conduct by other people on students is covered by other board policies. And the reason why we took that out is because regardless of who is allegedly harassing a student, we want the student to report the conduct in accordance with policy 248. So whether it's a student on student, whether it's a staff member on a student, anybody, we want the students to report in accordance with 248. The reason why it doesn't make sense, let's say you did have an allegation of a staff member harassing a student. The reason that it has to be handled under policy 248 is because when you look at 248, the definition of harassment is written with the school environment in mind. And when I say that, I mean, it has to, the conduct has to be of such a degree that it affects the student's educational performance. It impacts the student's educational opportunities. It wouldn't make sense for that type of complaint to be handled in accordance with policy 348, which is the staff harassment policy, because when you look at the definition of harassment in that policy, it talks about the harassment having an impact on the individual's work performance or on employment activities or opportunities. So anytime the alleged victim is a student, we want them to be directed to policy 248. And anytime the victim is a staff member, we want them to be directed to 348. But we needed to remove that sentence about the policy only applying to student-on-student contact. And that was the only change from last month.
Okay, well, I know I have a couple more questions along that theme when we get to me, but let's not start with me. Let's go to, where'd you go? Austin, there you are. You have questions, student?
Yes, I have a question. So would a victim benefit from knowing the red line complaint procedure so they could understand what actions are ahead of them, or is the procedure just listed in the Title IX grievance process document?
That's correct. The process for claims of sexual harassment is in that grievance process, and it's required as of August to be in a grievance process. So that there were new Title IX regulations. Title IX is a federal law that applies to school districts. There were new regulations that were effective in August, and they required us to develop a complaint procedure and to put it in a grievance process and to post that on the district's website. So that's why the link to the district's website is there.
Okay, thank you.
Yep.
Okay, thanks, Austin. Mrs. McMenamin?
I'm actually good because I had a question about the procedure too, but I just answered it, so I'm good.
Okay. Jeff?
I'm good.
Liz?
I'm just curious. I should have looked this up. I'm sorry. I just realized this. Came to right before the meeting. But how do we differentiate between harassment and bullying?
So the definition of the definition of sexual harassment comes from the Title IX regulations. The title of the definition of harassment is limited to conduct that's based on a protected class. So the conduct has to be, it has to be based on a student's race or color or religion or some type of protected class. Bullying is broader, and bullying is a term that's defined in the school code. That's sort of the slight difference there.
Does that help, Liz?
It does. I just imagine, I guess you can help people direct them to which is more, appropriate for the complaint. And then I guess related to that, because I remember, I just know in a person like bullying, sometimes it depends on where it happens, right? Does it matter on this, where it happens, where the location of where the harassment happens? Like at what point, if it's off school property and it's in someone's personal life, but they carry it over to the classroom, do we define that anywhere?
It's the same, the district's ability to regulate conduct is the same regardless of whether it's harassment or whether it's bullying or hazing or anything like that. And that sort of our jurisdiction to discipline or act based on student behavior or any behavior for that matter is addressed in some other policies. There are in the new Title IX regulations, just specifically with respect to sexual harassment under Title IX, there are some limitations where to have a Title IX claim against a public entity, the public entity has to have actual jurisdiction over the student or the staff member at the time the conduct is happening. But that wouldn't preclude us from acting upon harassment. If we had harassment that was taking place in a scenario where we were able to regulate it in any other scenario, whether we consider it Title IX harassment or just other harassment generally, we would be able to act one way or the other. It would depend whether or not it would fall under Title IX or not, but the district would still have an ability to respond if somehow it was impacting the student's education.
Okay, that's what I was just going to say. I think we're covered because we say if it impacts the student's educational. And then I had a comment. Should I go ahead and jump to the AR? You want me to come back to the AR? I just saw like this AR seems like the AR that we did for the harassment for employees is much more detailed. You know, we have like step 1, step 2, step 3, and I was curious why we didn't carry that over to this AR.
So for students, for the harassment that takes the form of sexual harassment, when students are the victims, the process is outlined in that grievance procedure that's online. That's the same for staff members. Now, generally, when you have students who are claiming harassment, are claiming harassment that's not sexual in nature, those complaints generally don't go through a formal process. They get handled more like they generally are handled more at the building level. And I think there's language in here that says something to the effect of complaints of, harassment.
Excuse me, Mr. Diazio, I'm going to jump in here for a second. It's okay, just in the interest of time, and since this is just a first read, could we put off AR questions since they don't have to do with moving things? I should have mentioned that in advance, given the time. Liz, is that okay if we wait until the second reading comes around?
Fine.
Stick, would you have anything having to do with policy? Because our goal is to try to get this off for.
I already asked those questions.
Yes. And the AR can be asked about all the way up through the adoption of the policy and beyond. So.
No problem.
Okay. Susan, did you have any questions policy-wise on this?
I do. So just my one question, and I read the red line, so I apologize. This is at the bottom of page 2 of 5. And it has to do with claims of harassment against a student by a non-student. To the extent that paragraph talks about following the procedures in Administrative Regulation 348, except if it's sexual harassment and then it's handled by the Title I coordinator, does that paragraph apply even if the non-student is a non-employee?
Is a non-employee or is an employee?
Is not an employee. So this was the question I raised last month about what if a student of ours is being harassed, for instance, by a parent? What policy covers that circumstance of harassment? And the reason I ask it is I thought we were going to put some line in here that said, or other applicable policies, but I don't see that line. And I don't see policy 9. I think it's 916, which is the complaint procedure.
906.
906.
Yeah.
And so I don't see that cross-reference, which I know you guys add a lot of cross-references at the end. So that part didn't so much concern me, but I don't actually see in this version where Ed, exactly what you said, claims by a non-student will either be handled by 348 or other policies as applicable or something. And I just don't see that line. So maybe if a parent is harassing a student, it's still covered by 348. I'm not sure.
And I do remember, Susan, that we talked about that last time, is even, going a little bit further and calling out public complaints, I think.
Right.
Not
So
just
I just
cross-referencing it.
So
not
I
sure I'm
think in that, under the guidelines in 248, the third paragraph that says the district will promptly investigate all claims, complaints, or other reports of harassment, including sexual harassment. I believe this, I'm thinking that this sentence should be, the next sentence should be amended, and it should say claims of harassment by a student, claims of harassment of a student by a non-student will be, we need to say here, I think, that student on student complaints will be investigated like other disciplinary investigations, and complaints by students by other non-students are intended to follow 348. And that addresses Mrs. Duffy's question as to why the AR in 248 is less detailed than 348. It's because we didn't duplicate everything in 348 in 248. We just simply refer in the policy. That's why it's referring to that process in 348. But I think the missing step is we need to add a sentence here. So it's clear that claims of harassment by a student against another student will be investigated like other disciplinary investigations. We need to add a sentence that says that if a student is being harassed by a non-student, AR 348 applies. And that's—
Well, that is in the next paragraph. But my question to you, Ed, is the inference when I see AR 348, the inference is that it's an employee. So I'm just confirming with you that whether it's an employee or not, if it's a non-student, you're going to follow policy 348.
Yes, that's the discussion that we had subsequent to the last meeting. We felt that that's the process that made most sense if a student was reporting the conduct, that this 348 procedure would apply, even though it technically in 348 applies only to students or only to staff. We determined that in the case where, you know, an adult, whether it be a parent or a volunteer or anybody else,
Okay, that's fine.
is harassing a student. So that actually answers both Mrs. Duffy's question and your question.
Yep. Okay. Thank you.
Thank you for teasing that out. It's all coming back to me now.
Great. All right. Amy, that was it for me.
Okay.
And
And
that's the reason why the other policies are then not cross-referenced.
Got it. Thanks.
so I know that this is a student-centric policy, and the definition of harassment makes it so because it talks about the student environment, et cetera. But then the definition of sexual harassment, and I know that's the official definition of sexual harassment, threw me off again because it's talking about an individual and person as opposed to a student. Do you not have the flexibility to put that in just to drive home the point that this is still, when it comes to sexual harassment, we're talking about a student, the way it's called out several times in the definition of harassment?
Well, keep in mind that the sexual harassment 248, it is a student policy, but where a student is primarily, it's where the student is the victim. So this policy would address a district employee sexually harassing a student, for example. This policy would be the policy that would apply.
Right. But it says
I
like,
may not be understanding the question fully.
yeah, so like for number 2, the sentence says unwelcome conduct, that harassment means conduct that satisfies one or more of the following. And number 2 is unwelcome conduct determined by a reasonable person to be so severe, blah, 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 that it effectively denies a person equal access to the district's education program or activity. That word person could be student, to just drive home the point that this is a protection. This policy is meant to protect students, regardless of where the sexual harassment is coming from. If that word person is interchangeable with student, it then drives home the point that this is about a student. And the same thing with number 1, the sentence there, conditioning the provision of an aid, benefit, or service of the district on an individual's participation. Basically, it's somebody trying to coerce a student's participation in unwelcome conduct. Is that true?
Yeah, those examples that you gave, your understanding is correct. The only reason I pause about changing the definition, and again, I'll leave it to the committee to decide, is that in the grievance process that's cited in all of these policies, this definition of sexual harassment has to be in there, and this is the definition that we use, because this is a Title IX definition. This came directly word for word from the Title IX regs. So the only reason I would pause is because you would have a definition of sexual harassment that says one thing in the policy, and then when you go to the grievance process, which is also referenced and incorporated into the policy, the definition is then going to be different in that document. I don't know whether that would be a concern to the group. Generally, when there's a legal definition, I
Stick with it. I know
err
you.
on the side of not
Yeah.
amending that
Well,
definition.
I don't know how everybody else feels, but I don't want to tangle with the lawyer's advice. So I don't know. Does anybody else have any reason why we shouldn't go with Ed's definition? I mean, the official definition. All right. well,
Amy,
Yeah.
Just looking at the
I
time.
I have to point out the time.
Yeah,
Yeah.
that's what I was gonna do.
Okay. Well, I have a couple more questions. So I don't think there anything that is with the some of them are so minor I can bring it up at the first read if I want to at the business meeting. The one thing I'll leave you with is the fact that before we go there, the most substantive of my questions is that under the guidelines, you're referring to student discipline, and 218 is not cross-referenced. So I was just going to ask if you thought that maybe that should be added in as a cross-reference, and anything else I can ask in 2 weeks if I need to. All right. How's that sound? Okay. All right. Well, thanks for the extra time. That was a lot to go through in an hour. We did not get obviously to 348, 448, or 548. So there's always next month. But in the meantime, we have a lot that's coming up at the end of this month.
Hey, Amy, I'm just going to make the suggestion that take a quick survey of the committee. You can probably push through 448 and 548 for repeal and see if I'm fine with putting those on the agenda for a first read for repeal. And I don't know how
think we can if we haven't gone through 348. That's the whole reason why we didn't push 448 and 548 through last time. And that's because we didn't get around to discussing 348, right? So I think it was the advice of our solicitor to wait for 348 before we push through a repeal of the two other policies. Is that correct?
Because right now, as it currently stands, 348 only applies to administrative employees.
Oh, right. Yep. Okay.
Okay, so we got to wait for those. So everybody okay with what we've done and what's headed on to the November business meeting agenda? And we'll come back in November and tackle the other things that we didn't get to today.
So it's
And objections to
248
that?
will move forward.
248 will move forward, yes. Right? Everybody, nobody has we got through everybody's comments, so I think that that's ready. And we talked about the other items, 815, 829, and 104. So we've got 4 things, I think, for the business meeting.
I think this was a really good meeting. I think the discussion was really good.
Thank you. You're not sitting here sweating trying to get through it all in an hour. But thank you for everybody's contributions. It's many hands make small work, or something like that. Anyway, let's see. New business, anyone? No? Okay. Is there any public comment that's come in?
There is no public comment.
Okay, and I want to thank the Finance Committee for being patient with us. We had a big agenda, and I think we were as efficient as we could be given the givens. And thank the whole committee for your work today, and we'll see you all for our next policy meeting in December, if not before. Bye.
Bye.